My name is Carolyn Madden, and I'm a member of the League of Women Voters of Washtenaw County. I welcome you to this online forum, co-sponsored by the League, the Dispute Resolution Center, and the Washtenaw County Bar Association, featuring candidates for 14A District Court Judge. The candidates will be on the ballot in the primary election on Tuesday, August 2nd. The League of Women Voters works to expand voter rights and educate voters. The League, the Dispute Resolution Center, and the Washtenaw County Bar Association are nonpartisan organizations. None of the co-sponsoring organizations endorse judicial candidates or other candidates for public office. We are providing this forum as an opportunity for candidates to express their views related to their candidacy. Statements expressed by the candidates are neither endorsed nor opposed by the co-sponsors. Also, the co-sponsors do not certify any candidate responses to questions as accurate. Voters are encouraged to fact-check information shared at the forum. The League, the Dispute Resolution Center, and the Washtenaw County Bar Association bring you tonight's forum because we believe deeply that respectful sharing of views on community issues is vital to the functioning of our American democracy. Our moderator this evening is Belinda Doolin, the Executive Director of the Dispute Resolution Center. She will explain the format and get us started. Belinda?
Thank you, Carolyn. And now it's my honor to introduce the 4 candidates running for 14A District Court in the August primary. Fawn Armstrong, Carl Barr, Stuart Collis, and Toshiro Feaster. Thank you again, candidates, for participating in tonight's forum. The forum will follow this format. Each candidate will have an opening statement of up to 1 minute. Each candidate will have a closing statement of up to 90 seconds. In between, I will ask questions that came from the community. Each candidate will have 2 minutes to respond to a question. At appropriate times, the timer will raise a sign on her screen indicating the time remaining, 30 seconds, and then stop. If you have used up your time, you will be allowed to finish your sentence, and then your microphone will be muted so that other candidates will have an equal opportunity to participate. The candidates will begin speaking in alphabetical order. Depending on the number of questions, all candidates will have an opportunity to be the first or last to answer the questions. We are now ready for the opening statement, and we'll begin with Ms. Armstrong.
Good evening. My name is Fawn Armstrong. I'm running for 14A District Court Judge. I am a mother of a 13-year-old. She goes to Saline Middle School. And I'm also recently married. My husband is Christopher Shemke. He's a criminal defense attorney. I've been a prosecutor here in the county for the past 10 years. I'm currently in circuit court. I did 3 years in appeals. I also spent a lot of time in district court, specifically about 5 years directly in the 14A district courts. I also worked previously for 2 civil law firms. I'm also a U.S. Army veteran. I spent 8 years in the Army Reserves. I did 1 tour of duty in Iraq. I earned a Bronze Star for merit for my time there, left as an E5, and left my term of service as an E6 staff sergeant. And I hope that I can speak to you today more about my candidacy. Thank you.
Thank you, Ms. Armstrong. And now, Mr. Barr, may we have your opening statement?
Sure. Thank you, Belinda. I'm running to be your next 14A District Court Judge. I believe my deep roots, broad ties, and 20+ years of service to this community do make me the best choice to be your next judge. I'm the only candidate that's grown up and went to school in the district. I'm an Eagle Scout from the district. I'm the only candidate that has prosecuted and defended criminal cases in the 14A2 district, which is what Judge Tabby is vacating, as well as both sides of civil matters. I worked 20+ years for the city of Ypsilanti, as well as other municipalities and other people in the community, Why does that all matter? Because the community and court know me and they trust me. Trust is one of the most important things that I believe that the judicial system needs. I also have the endorsement of the outgoing judge, Kirk Tabby, who knows this court better than and community better than anyone else. I ask your vote on August 2nd and November 3rd. Thank you. November 8th.
Thank you, Mr. Barr. Now we'll move to Mr. Collis for your opening statement.
My name is Stuart Collis, and I'm hoping that everyone here will be voting for me for 14A District Court Judge. I am a litigator with 26 years of experience, giving me the most experience of any candidate in the law. I am a Washtenaw County resident for 20 years. On top of that, I'm licensed in 3 state courts and 5 federal courts, so I have a vast amount of experience. I'm married to my wife, who is a former Pontiac police officer. We have 2 children in the Saline School District. One is an outgoing freshman. The other is a incoming 7th grader. We have a dog who is, quite frankly, my favorite child, Jazzy. Hopefully, I can count on your vote, and I will look forward to speaking to you more further in this program.
Thank you, Mr. Collis. And finally, may we have your opening statement, Mr. Feaster?
Thank you, Ms. Doolin. Appreciate it. Good evening. My name is Torshell Feaster, and like the rest of the people you've heard tonight, I am a candidate for 14A District Court Judge. I am a local attorney. I currently serve as a criminal defense attorney with the Washtenaw County Public Defender's Office. I previously have worked in a solo firm that I created where I did landlord-tenant, civil work, bankruptcy, and family law. I have 15 years of experience serving people and learning how to deal with difficult situations. I am an Eastern Michigan University graduate. I am a husband of a lovely wife, Dr. Rosalind Aiken Feaster, and I have 2 lovely daughters. I'm excited about this opportunity because I believe we can make some real change to our justice system. We can change the way that we interact with our community. We can move our society forward. And I'm looking forward to the opportunity to tell you why I feel I'm the best candidate for this position. I also have some endorsements of great judges on our bench, including Judge Conlon, Vandenberg, Connors, Freshour, and Simpson. Thank you.
Thank you, Mr. Feaster. Thank all of our candidates for their opening statements. We will now move to the questions. I'll read the question once, and it will not be repeated unless you request me to read it again. We will start with Mr. Barr with the first question. Michigan law provides for problem-solving courts, alternative courts that handle cases involving mental health, addiction, or veteran treatment issues. Please discuss the advantages and disadvantages of such courts and the criteria you would use to identify cases for transfer to a problem-solving court.
Thank you very much. So the courts in question being a mental health court, substance abuse court, and veterans court are excellent alternatives for diversion as well as better rehabilitation and reduce recidivism. They are parts of my platform to bring those courts as well as explain or to bring in others into the 14A District Court. As everyone knows, they have been pioneered in the 15th District Court. I think excellent candidates would be those that have had a high amount of recidivism, that it is most likely quite clear in looking at the commonality of those cases that there is something behind what and why they are offending. Typically, obviously, that they straight to the name of those dockets, the mental health docket, addiction docket, veterans docket. The downside, budgetary. Currently, there isn't budget allocated for that. The upside, the treating the problem itself and the reduction of recidivism. Thank you.
Thank you, Mr. Barr. Same question, Mr. Collis.
It's important that we have substance abuse, veterans court, and alcohol abuse courts, sobriety courts, etc. It's a shame, and it's really, quite frankly, embarrassing that 14A District Court, which covers the greatest part of Washtenaw County, excluding Ann Arbor and Ypsi Township, does not have any specialty courts. It is something that I feel very strongly needs to happen. One of the things that's been identified throughout is that people who, many people who come before 14A on misdemeanors are there because of other problems, alcoholism, poverty, substance abuse, or mental health issues. And if we can address those things at their source, we're not going to be seeing people coming back into the criminal system. We're not going to be wasting our resources and taxpayer money on that. With regard to the second part of the question of identifying them, unfortunately, the judge's portion is to generally judge. Right now, it is the defense attorney's obligation to bring that forth as an option, and then it is then approved or goes through a process through probation and a substance abuse evaluation or a mental health abuse evaluation. And then it is brought to the attention of the judge to approve or disapprove. Personally, I think everyone who is worth a shot because without giving people an opportunity, we are just increasing our costs in the jail system, which is increasing the taxpayer costs, and that's not healthy for our society. So it's incredibly important that these things be brought to the attention of the judge, and it's incredibly important that the judge give an opportunity for people to get into these programs and stay out of the system, in the criminal system.
Thank you, Mr. Callis. Mr. Feaster, same question.
Thank you, Ms. Doolin. Obviously, I'm a big fan of specialty courts. When I first came out of law school, I clerked for a judge who was in the process of creating a mental health court. And I saw how she went about creating that system and the benefits that it created to a lot of people who needed those resources. Later in my career, I was able to help create some specialty courts where I helped to create a blight court to help clean up a city, make sure that it maintained its beauty and uplifted the residents by having a beautiful place to call home. And after that, I helped to create a homelessness court, another type of specialty court that I thought was very important because that allowed our unhoused population to have their bench warrants cleared up by bringing a judge to those homeless shelters and holding court right there in those facilities. That way, those people could feel comfortable and have their issues addressed. And once their bench warrants were cleared, they became eligible for federal dollars to receive federal housing. And so we're able to get people off the street. So I'm a big proponent for specialty courts. And I think the 14A needs to do a better job of adding some of those to this county and helping the population that needs those resources. I'm currently in the works of creating a new specialty court with Judge Simpson called the Youth Court or Fresh Start Court. That's a court that we're trying to create to touch the youth of this community and to be able to impact them so that they, at the early stages, at their first interaction with the criminal justice system, can be able to go through a diversion program and hopefully get them on the right track so that they do not continue to come back through the system. So I am excited about the progress we're making, what I'm able to do now as just an attorney, and what I'll be able to do even better if I get this seat and I'm able to be a judge in the community. And so I'm excited to widen the bounds and to really make sustainable impact in the community. Thank you.
Thank you, Mr. Feaster. Ms. Armstrong, same question.
Thank you. Some of the benefits of these specialty courts are one, that you get either a reduced charge at the end of it, or sometimes a dismissal of all charges. So it's a huge motivator for people to really invest the time and take the programming seriously. Also, in terms of sobriety court, you can get your license back quicker. There's a partnership with the state so that you can get a sober link in your car so that you can drive sooner than if you don't go through that program. Other benefits are that you're supported on multiple fronts. There's so many people in that court, in that program, supporting you. For example, getting you counseling if that is something that you need, substance abuse assistance, helping you get your benefits. That's especially true with the Veterans Court. There's so many benefits out there that veterans just don't understand the federal forms or how to get those benefits to them that they are deserving and qualified for. And as a veteran, I know we do have that 1 in 15th again, I echo my peers here. We don't have one specialty court in all of 14A. I've been speaking with a couple of other judges, a lot of them downriver that have specialty courts. They've agreed to assist me in starting a sobriety court here or a other specialty court because they've done it there. One is Judge Clifton, retired Judge Salamone. They're big proponents of these programs. One way to identify, I think, those issues, one is by the type of crime itself. The other is, I think, experience. One thing that we see in the prosecutor's office, substance abuse crimes, substance abuse issues. A lot of those people have crimes related to thefts. So multiple retail frauds, multiple home invasions, other larceny charges because they're trying to support their addictions. And so that's one way to identify the issues. Thank you.
Thank you, Ms. Armstrong. We'll go now to our question number 2, and Mr. Collis, will start with you, okay? Please describe your understanding of the special COVID-related procedures ordered by the Michigan Supreme Court and currently in effect for handling tenant eviction cases.
So this is something that is actually possibly going away soon. So right now with landlord tenant, the Michigan Supreme Court came down with a new set of court rules. And the new set of court rules basically said this. First, that there's going to be a hearing where the landlord, where the tenant needs to appear by Zoom. If the tenant does not appear, they're given an opportunity to appear in person or again by Zoom. So there's one automatic adjournment by virtue of the fact of the COVID pandemic. Then after the that hearing, the second hearing is if there's a second no-show, then a default judgment may be entered. Without going through, if the tenant does appear, they're of course given the opportunity to be told their rights to have an attorney, to have legal representation, and they're usually given another adjournment. There's also the opportunity for, if it's a non-payment of rent case, to access SARA funds. And SARA fund process is a whole separate procedure, which may or may not be ending at the end of this month. I believe the program has been announced that it's going to be closing for applications at the end of this month. So if they apply for SARA funds, then there's a process by which they go through a social worker, and then there is a additional time, money that can be done, and then they're given the opportunity to have a conditional dismissal if the funds are paid. That will also mean that there's an extension of the lease, so they can't be evicted for the 30 days thereafter, which also means that a notice to quit cannot be issued in that time period. So it's a highly technical area, but it's a very important area for a judge to know.
Thank you so much, Mr. Collis. Same question for you, Mr. Feaster.
Thank you, Ms. Doolin. Obviously, I'm not going to repeat everything Mr. Collis just said. I don't practice landlord tenant right now, but the summary of what I understand it to be is this. The Supreme Court was trying during COVID to make sure that people did not wind up on the streets. The Supreme Court was trying to find ways so that people who were suffering as a result of the pandemic, as a result of lack of employment, people losing their jobs, businesses closing down, trying to find ways in which we could keep people in their homes and not have people out on the street. The Supreme Court is doing what really courts should have been doing for years in advance of COVID. We have to do a better job of making sure that we connect people with the resources, such as the SARA funds we have right now, to make sure that the landlord is getting the funds that they're entitled to, but also making sure that the tenant is being housed. It only hurts our community, only hurts our state if we don't work together to try to make everyone whole and keep people in their residences. And so I'm excited about what the Supreme Court has pushed down. I'm hopeful that COVID has taught us all a lesson, it taught many judges a lesson, and helped us to realize we have to work together because we're only as strong as our weakest citizens, and we have to uplift them so that we can make our communities better. And so I'm excited about what the Supreme Court has pushed down, and I'm looking forward to seeing judges continue that after the mandate is lifted and hopefully continue to help people. Thank you.
Thank you, Mr. Feaster. Ms. Armstrong, same question.
Because I think that Mr. Collis definitely gave a pretty accurate summary of exactly what those orders are about. And also Mr. Feaster added some very good points there. I also don't do landlord tenant law currently. I did back when I did civil law, and my understanding again is that some of these rules are going to be changing probably very soon and most likely before the judge takes over. My biggest understanding of the interplay between landlord tenant law and that new administrative order that came down due to COVID, the issues that are being arising from that have to do with the delays that are being caused by that administrative order. I believe originally they're supposed to have a hearing within 10 days of filing, and then completed that proceeding within 56 days. But because of the administrative order that came down previously, they were not able to complete that in time, and the district courts were all adjourning them out for a long period of time. I do feel that there should have been more programs in place to support renters during that time, because a lot of people did lose their jobs. And I think the courts are facing a backlog right now, trying to get all of those court cases caught up. And that's something that the district court, that whoever takes this position is definitely going to have to address, and also to add more dockets to their schedule to ensure that these cases are handled quickly and procedurally according to all of the rules. Thank you.
Thank you, Ms. Armstrong. Mr. Barr, same question.
Thank you. I'm not going to repeat what others have said. Mr. Collis did a good job of outlining most of it. As background, the landlord tenant happens in the district court pursuant to Summary Proceedings Act. It's been around, I think, since the Revised Judicature Act 1986. Overlay to the current vernacular, as you mentioned, the Supreme Court's administrative order, but even before that, there was Governor Whitmer's executive orders, which didn't allow people to be put out of their residence. We got more, obviously, authority and tools with the SARA funds that came in. It was being administered through the Salvation Army, which between the Salvation Army and legal services, I think they all did a tremendous job, an extraordinary workload to get these matters administered, which, yes, backed up the dockets, as I think others have mentioned, and helped a lot of tenants stay in their property. The ones that I've handled, I saw between $10,000 and $15,000 to go to help the tenants, not only with their rent, but with regards to utilities and otherwise, sometimes future rent. I think a downside of the program was that tenants, if they had to stay in the property to get the funds. So if there was some other problem with that property that they absolutely had to vacate it to get to another place, they didn't get the funding to help vacate the place that they were out of. This has been very trying times, I think, for everyone, particularly the court. If I haven't said it already today, I would give great thanks to the court staff for administering these things, learning Zoom, these extraordinary long dockets due to these delays. I'm thankful to be living in these times. I'm thankful that we have Zoom so we can be working in these times, and for everyone's help to protect these vulnerable people. Thank you.
Thank you, Mr. Barr. We will move to question number 3, and Mr. Feaster, you'll be the first to answer. In light of the recent national incidents involving the police and death of African Americans, what role could restorative justice practices play in the judicial system and in the 14A District Court specifically?
Thank you. Obviously, the situation that we have in this country right now, dealing with the death of unarmed people of color in this country, is devastating and frustrating. And it should be frustrating to all of us, and I hope it is. I know for myself, I had a really difficult time back in 2020 when all this stuff was really at the forefront of all of our minds and all of our attention. I think that it is huge that we have some reform and that we interact better with the entire population, and that we are not threatened, and that we feel we have to have to be scared of people to the point to where we take a life. I think being a police officer is an honorable job. And I think we have a lot of honorable people who do that work. But I think it's a difficult job and it takes a lot of courage. And you have to be willing to hold your gun in your holster rather than to pull your gun sometimes. And I'm hopeful that we've learned something through George Floyd and Ahmaud Arbery and been able to take that moving forward so that we do not continue to have these same types of issues. In particular with the court system, we have to do a better job of dealing with the bias that we have in the court system. We have to do a better job of dealing with the inequities. If you look at the population of the African Americans in our community being 12, 13% of the national population, but you look at the numbers of African Americans in our prison system, I believe we're over 60 or 70% of the prison population. I think you can see on its face that there's something wrong there. And I think we have to do a better job of making sure that we address those issues. And as a judge, I will make sure we address those issues. I will make sure that we have equity in sentencing and that the sentencing is not biased. And I will bring my experiences and my exposure into those judges' meetings to share with my colleagues to hopefully make sure that they also do not have any bias in equity and provide equity in their sentencings. Thank you very much.
Thank you, Mr. Feaster. Ms. Armstrong, same question.
Thank you. One thing that I see as an issue, especially in this county, there are people that are afraid of the police, that won't speak to the police, that don't want to even report a crime to the police because they're afraid of what would happen to them. I've spoken to some officers and again, understood and explained, and they are on the same page. If they just don't really have the manpower or the time. But we need to have more police officers just in the community talking to people and instead of enforcing, and just being someone who's around, who is a trusted figure, who's not just someone who's coming after them. In terms of restorative justice, I think that would be a great way to bridge that. Especially, I would say, maybe in non-assaultive resisting and obstructing cases, perhaps when a suspect is merely running from the police and not assaulting them. That would be a case that could be brought instead of the court, instead of charges, having restorative justice, where there is a mediator there, where the police officer can sit down with that suspect, with that person, and talk it out, and perhaps have some healing and some understanding so that the people in this community and people of color can see the police officer as a person. And so the officer themselves can see that person of color as a person, and just be able to have that time to speak, have restorative time, have time of healing, and making both sides understand where the other side is coming from. I think that would be a great way to bridge the gap between the people's fear of police and the police officers, need to do their job, and also facing a very scary job themselves, and being having to police this community. Thank you.
Thank you, Ms. Armstrong. Mr. Barr, same question.
Thank you. In the late 90s, City of Ypsilanti hired a police chief named Leonard Sapinski that brought in, at that time, a relatively new concept known as community policing. Community policing is that you police what the community wants enforced. You don't top down from the police enforce what the police want. And in addition to that, you enact outreach. You immerse officers in the neighborhoods, much like happened years and years ago before patrolling by vehicle became commonplace. And the goal of that program, which is to build trust and confidence between the community and the police department, very similar to my top priority of building trust and confidence between the community and the police department. Now that today's vernacular is courtesy policing, it's very similar thing. That, in my opinion, that bridging the gap, as I think Mr. Feaster said, touching on the fear. I've heard from members of the community that are fearful of the police. I know police are fearful for their own safety. Basically, when a police officer is pulling over someone or interacts with a person, they may both have the same fears for their own safety. And the biggest lack there is communication and understanding. when I was in Ypsilanti High School, there was a coach on the football team. I wasn't really a player, but I was on the team, who said, hey, if you get pulled over, this is what you do. This is what you don't do. The city of Chelsea has a pamphlet at their police department, what to do when you get pulled over. It's that type of communication and understanding between the police department and the citizens, what is woefully needed to stop these type of interactions on the roadside and these tragic deaths. I could go on much longer, but my time is about at an end. Thank you.
Thank you, Mr. Barr. Mr. Collis, same question. And you're muted.
I was going to say, Ms. Doolin, would you please repeat the question? I want to make sure I'm answering appropriately.
Absolutely. In light of the recent national incidents involving the police and deaths of African Americans, what role could restorative justice practices play in the judicial system and in the 14A District Court specifically?
Thank you. When I was a beginning practitioner, I remember being in Oakland County and doing criminal defense work, and disproportionately, even today, most of my clients are Black, and that's not right. That means there's something going on, especially as Mr. Feaster brought up, 13% of the community is African American. And yet I would tell you that probably 60-70% of my clients are African American when I'm doing criminal defense. And when I was in Oakland County, I would have people time after time after time tell me I should have never crossed 8 Mile. I should have never crossed 8 Mile. And that is a problem. And this is the problem. Restorative justice is a great concept. It's a beginning. It's just like a beginning, like the sobriety courts and victims. It's getting to the heart of where people are at, because we have to meet people where they are at, not where we are at. We have to meet people there so that we can help bridge that gap between the victim, and we can also bridge the gap between the offender, because usually there's a reason for why these things are taking place, whether it is bias from the police themselves, or whether it is something that's more endemic to the individual as the victim or as the offender. Restorative justice is extremely important to bring those people together so we can reach understanding and keep people out of the system. Because the more that we have people in the system, the more that we're hurting people, we're hurting the opportunities for people to be uplifted and then to make themselves productive members of society. So if we could keep them out of the system in any way possible, it's going to be helpful. Thank you.
Thank you, Mr. Collis. We're going to move to question number 4, and Ms. Armstrong, we'll start with you. What are your views on the use of alternative dispute resolution mechanisms in the courts, such as peacemaking and mediation, and their impact?
I love the idea of having these alternative dispute resolution programs or mediation. I think it's important to ensure that both parties actually want to participate in that program and not to just order, as a matter of course, every single case to mediation. But if both parties want to have that program, I think, and they have equal bargaining power, it's great. I think it saves money. I know mediation does cost, but in terms of also doing probably a jury trial, this would be a more reasonable cost. But it allows both parties to be involved in the program instead of just having someone decide something and being told what to do. Hopefully it heals them in that relationship, and hopefully it empowers them. But I would completely support it in my court. And I think that I feel like it really changes it from an adversarial program or case to more of an understanding, which is something I think that is very helpful to people in terms of moving on from something that they're involved in. So I agree with it. I think it's important, and I like that it gives everyone an equal voice and a chance to be heard. Thank you.
Thank you, Ms. Armstrong. Mr. Barr, same question.
Thank you. The two that you mentioned are great alternatives, peacemaking and mediation. I mean, obviously the DRC does a great job and is extremely affordable for litigants, whether that be in the district court, matters under 25,000, or small claims, and frankly, even circuit court. The one factor in some of those matters, which we see more often in the family arena, is whether there is domestic violence and the power imbalance. Obviously, that needs to be factored in with shuttle diplomacy, being that the people aren't in the same room and the mediator goes back and forth, can work very well under those circumstances. But I think with the new disclosures on the domestic side, obviously that's helpful for the mediator to understand. I personally am not in favor of the court rule change with regards to case evaluation and removing the mandatory penalties for rejection of case evaluation. The vast majority of the cases, the monetary cases, the civil cases that I have in district court would settle in case evaluation. And I personally don't think that change is a good change. Alternate dispute resolutions, and even outside of court being arbitration, are typically faster and easier for the litigants to do, and they can draw their own result, which typically they know much better than the trier of fact, particularly on any type of civil matter, what might work best for them. Sometimes it's a dollar amount, sometimes it's some other case. Probably the hardest cases to resolve, whether that be by the judge or in mediation, are people that were formerly friends or in a relationship. I'd be happy to continue use of the DRC, obviously with the 14A2 District Court, and appreciate the work that you do. Thank you.
Thank you, Mr. Barr. Mr. Collis, same question.
I think, I'm not 100% certain, but I think I'm the only person here who's a candidate who's gone through the 40-hour course to become a mediator and be on court-appointed lists to do mediation. In fact, I've renewed every 2 years, except I think during the pandemic I might have lapsed. But I have been doing, I'm obviously a huge believer in mediation. I've not only been appointed as a mediator in the Jackson courts and the Oakland courts, I'm on the Washtenaw County list, and I was actually trained by the DRC here in Washtenaw County, and I with Zena Zameta. So mediation is a big part of my life. I've actually been doing it since before there was the courses. When I was in Oakland County, one of the requirements of staying on the court-appointed list was that you did a certain amount of hours of small claims mediation. So I'm very familiar with the process. I've been doing it since the 90s. And I think it's absolutely an invaluable service. What is more amazing about mediation is that, of course, when people can get together and agree, settlements and judgments and conditional dismissals and all kinds of other agreements are maintained 80% of the time, as I understand it, which means that if we could get people in the same room and to talk and to listen and understand, those agreements are going to be binding and people are going to be less confrontational, and they're not going to be back in the court system, which is exactly what we want. The peacekeeping court is another great mechanism. It's great also for, again, the restorative justice sort of thing, because you're getting victims and people together and people so that they could hear each other and move on from the hurts of the past and move forward. It is so important that we not dwell on the past and that we move forward in society so that we can actually do things that are productive as opposed to dwelling on the harms that we've already experienced. So mediation is extremely important. I hope to help out in that aspect. Thank you.
Thank you, Mr. Collis. Mr. Feaster, same question.
Thank you, Ms. Newell. Obviously, I'm a big fan of mediation. Part of the problems with the court system, particularly for our pro per litigants, is cost. Court is not cheap. I think one person said that you can get married easy, but divorces are expensive. And so I think the need for mediation is pretty huge. It's going to help our citizens be able to resolve things without having to pay a lawyer $350 an hour or $400 an hour. And so mediation comes in tremendously helpful to be able to help people get the access to the justice that they want at an affordable rate. And having organizations like the DRC and other groups that can help facilitate that and provide those services at no cost or low cost is also huge for our community. So I'm a huge fan of that. When I did family law prior to taking the job I have now, it was huge to be able to have a husband and a wife sit down together and negotiate the division of their assets, as opposed to having to pay me a fortune to fight about it. I didn't like fighting over washer and dryers, and I'm glad that mediation came in to help resolve a lot of those issues. As it relates to the peacekeeping court, Judge Connors is the judge right now of the peacekeeping court. That court is huge. I had an opportunity to sit down with Judge Connors and to discuss that court, his vision for the court, and where he wants to see it go in the future. He's not going to be here to do it forever. We have to make sure that whoever steps in for him next picks up that mantle and runs with it. We need to expand that because the impact it has on our community to making the people feel whole and to moving people forward is tremendous. And so we have to do a better job of growing those type of programs, making sure they live and expand and not die. And so I'm a big fan of mediation and peacekeeping, and I'm excited to see them continue to blossom and grow in the future. Thank you.
Thank you, Mr. Feaster. We're going to move to question number 5, and Mr. Barr, we'll start with you. What is the relationship between judges and prosecutors? Please identify 1 or 2 specific steps they can take together to improve the justice system.
Great question, because one of the things that I really want to do if I'm your next 14A2 district court judge is reenact the bench bar meetings. And that was a monthly meeting between the court, the prosecutor, and the public defender, as well as municipal departments and the police department, to share information about what's going on, not only between prosecution and the court, but with the community at large. And one way that that can be very helpful, a very easy example, is when there's communication between the prosecution, the court, and the police department, obviously not behind the ears of the public defense, that on when things would be scheduled, it can relieve overtime burdens at the police department, as well as not have an officer come in after a 12-hour shift who's very fatigued that would affect their testimony. Predominantly, it's communication between what is being seen, but ultimately it's the prosecutor's responsibility on charging that sets the tone for what acceptable behavior is in the community. Past that, there are conferences that occur multiple times during every docket at 14A2 district court between the court and the prosecutor's office, but the defense is always a part of that. Separately but I guess just with regards to scheduling on things when warrants would be needed, weekends, things like that, there can be a great deal of court efficiencies gained by that communication. Thank you.
Thank you, Mr. Barr. Mr. Collis, same question.
Could you repeat that question again, please?
Yes. What is the relationship between judges and prosecutors? Please identify 1 or 2 specific steps they can take together to improve the justice system.
There's a relationship between, quite frankly, everyone in the court system, whether it's a judge and a prosecutor, a judge and defense attorney. It's a function of people who have seen each other all the time. However, I don't believe it's appropriate for a judge to have relationships that are extensive with the prosecutor any more than it is with the defense attorney. The prosecutor is part of the executive branch, and the court is part of the judiciary. Now, the prosecutor has a job to do, and so does a judge. When a prosecutor and a prosecuting attorney and a judge get too friendly, it creates hardships for defendants, and I don't think that's appropriate. Now, that's not always true. We right now have a forward-thinking prosecutor in Ellie Savitt, who is trying to work with the prosecutor's office and work with judges in order to create more programs to assist criminal defendants. But at the end of the day, a judge's job is to rule on the law. It is not to work with the prosecutor or work with the defendant. It is to rule on the law. We call balls and strikes. We are not there to make friends with one side or the other to give either an advantage. That being said, a judge can always try to assist the public in every way possible, and there are many things that could be done, but for the judge and the prosecutor to work alone is inappropriate. Thank you.
Thank you, Mr. Collis. Mr. Feaster, same question.
Thank you, Ms. Doolin. I'm going to ask you one more time to repeat the question, please.
Yes. What is the relationship between judges and prosecutors? Please identify one or two specific steps they can take together to improve the justice system.
Okay. So generally, if you look at how our court systems are set up, you look at Saginaw County, I believe Oakland County, Genesee County, what you normally see is you see your courthouses and you have your judges in your courthouses. And then you will often see your prosecutor's offices also in those same courthouses. And so to the outside public, it presents the appearance of impropriety. It gives the public the idea that judges and prosecutors work hand in hand, they work closely together, and they have a relationship. And so when I deal with my clients, a lot of them feel like the prosecutors have the judge's ear because they work in the same building and they're very close together. And so what we have to do is have to break down those views that the community has, that judges and prosecutors are one and the same and they're working together against defendants. What the state's done to kind of make that better is we've created the Michigan Indigent Defense Commission. And that commission has come about and created the resources to increase public defense in the state. You have public defenders' offices popping up all across the state where they're getting better resources. I won't say equal resources, but closer to equal resources as prosecutors' offices to be able to defend clients, just like the prosecutors prosecuting defendants. And so what we have to do, we have to break down that appearance of impropriety where it looks as if the prosecutors have a leg up on defense attorneys by virtue of their office locations or their connection to the court system. And so what I want to do is I want to continue to help the MIDC grow. I want to continue, like Mr. Barr said, to do things above board with transparency. That way the public can see that just like Ellie Savitt is in a room with a judge having a meeting, so is Delphia Simpson. And so we're seeing the judge and the defense attorneys there together, above board, doing good work for the community and avoiding the appearance of impropriety.
Thank you, Mr. Feaster. Ms. Armstrong, same question.
Hello. As I've been listening to everyone's answers and pondering this question myself as the only, I think, long-time assistant prosecuting attorney on this panel, I kept thinking about the relationship between myself and the judges. And my thought always went back to my relationship with the public defender or the defense attorney that I was in court with, because we were the ones that were really working together on a lot of these cases. Sometimes someone has an issue, perhaps a substance abuse issue, a mental health issue, where the public defender and I are trying to work on some sort of resolution, but we need the judge on board. So we would always work together and bring that to the judge together. And I think the relationship was then all three of us, not just with the prosecutor and the judge. And the relationship was one of, I would say, just trusting in the prosecutor and the public defender that we were bringing a fair resolution and being very upfront and seeking their help and guidance. I do think there are some ways, though, that the prosecution, or at least the prosecutor's office, not specifically a prosecutor, and the judge can work together. And those are specifically, if you need to make a problem-solving court, you're going to need the help of not only the prosecutor, but the public defender, because you need one of those from each department to be staffing those special dockets. Also, I know that one thing I'd like to do is warrant resolution days. days where people can walk in and turn themselves in on their warrants, resolve their tickets. So you also need a prosecutor there, you need a public defender there, you need staffing, you need the court. So those are other ways that we can all work together. Also having days where we can work on getting people's licenses back, having them come to the court, getting the legal advice from attorneys from the community, being able to maybe walk into the courtroom. Sorry, my time is up, but thank you.
Thank you, Ms. Armstrong. We're going to go to our last and final question, and we will begin with Mr. Collis. Many citizens do not understand how the courts function. How would you increase that knowledge in the community?
Well, one of the things I pride myself on is being a good teacher. When I bring a client into the office, the first thing I do is start explaining them to what the law is, what can be done at every stage. And I would continue that in the courtroom. And I think it's important that whether it's a civil litigant or it's a criminal defendant, understand everything that's going on, and there needs to be an explanation. So for example, if it's a preliminary exam, one of the things that should be explained is, look, this is a probable cause hearing. That means that the people have to show with probable cause that a crime has been committed, and this is that you were the person that committed that crime. If it's a civil case, you need to explain certain things about the rules of evidence, what may be hearsay and not hearsay, because in many cases, civil litigants in the district court are representing themselves, and they're not represented by an attorney because they're not entitled to a court-appointed counsel in a civil case. So it's extremely important to say, look, defendant, this is hearsay. Anything that someone doesn't come to the court and say in person, that's something, an out-of-court statement made for its truth is not admissible. We can't hear that. We need to hear from that person directly. And one of the things that I'm really, I'm looking for the word, but I really want to see happen is that we bring a group of people together to help civil litigants in terms of defending their cases, because on small cases, they could actually have their lives turned upside down. So getting a group of people to teach people about what the law is and what it can do is also very important as well. But in the courtroom, the judge is not only the referee, but also has to be the educator and make sure that everyone understands what's going on. Thank you very much.
Thank you, Mr. Collis. Mr. Feaster, same question.
Thank you, Ms. Doolin. There's only so much that a judge can do during 8 to 5. Our days are packed. You're going to have a full docket. You're going to be trying to get through that docket and touch everybody you can touch. The way that a judge can really educate the community and make sure that people understand how the system works is going to be outside of that 8 to 5 block. And so what a judge really needs to do is be engaged in the community in which they serve. And so if one of us wins this seat and we're going to be in Ipsy City, then we have to be engaged in that community. We need to do things outside of the courthouse. And so I think that the judge has to go to churches and hold meetings and educate the public about how the court works. The district court is thought to be the people's court. That's the court that the people are most likely, an average person is most likely to interact with when they come to court on landlord-tenant, on a misdemeanor, on a traffic ticket, on anything like that. And so being engaged at churches and community centers, maybe having quarterly town hall meetings. I used to do something with a judge, and we used to go to a college, Mott Community College, and we used to do a forum every year called You and the Law. And we would work with the community and with the youth, and we would educate them about how court systems work, about how what you're going to do when you go through a court system, what the proper attire was, how to really be professional and deal with life issues. And so I think that's what a judge is going to have to do. And we're going to have to make sure that we don't just sit up on our high perch in our black robe and be distant from people. We've got to be engaged. This job is more than 8 to 5. This judge this role is a role to serve. I'd like to think whoever gets this seat is going to be a servant leader in this community. And that means getting off that bench, going out and meeting people and educating them about how our system works and making them comfortable with you and the court. So thank you.
Thank you, Mr. Feaster. Ms. Armstrong.
Hello. Um, So I know when I was in 14A, 14A2 for quite some time, we had a lot of pro per defendants. And I think that was because a lot of them were very small misdemeanors, traffic offenses. They either didn't have appointed counsel or they didn't want it. So I had to spend a lot of time as a prosecutor running back and forth to the wall to be able to take time to explain the process, because it does take a little bit more time that normal people or normal cases with that have appointed or retained counsel, they get to have those meetings outside of the courtroom. But sometimes you have to drop everything and do it inside the courtroom to make sure that everything is proceeding with knowledge, with understanding, and the process is completely fair and everyone's constitutional rights are being upheld. I've seen judges do that several times. I've seen some judges get frustrated and not do that. And that's something that we just can't do, because we have to understand that a lot of people coming before the court are not versed in the system. They don't know what's happening. And it's also probably the scariest day of their lives being in court. They don't know what's happening. They don't understand. They just see big numbers of maximum penalties. They don't know if they're going to jail. And we have to have that compassion and that understanding and take the time. Yes, you're going to have long dockets. That's fine. But you're going to have to be able to take a moment, maybe adjourn so that that person can get some advice. But I agree with Mr. Feaster as well. And I think that we need to have a judge who is engaging with the community. One thing we used to do also at 14A2 is give out pieces of paper that had all the explanations on how to get your driver's license back, because there's a bunch of steps that we would give out. And I think that's something the court can do as well. Some sort of pamphlet. I also like the idea of having a forum or Zoom meetings of just let's chat with the judge, making sure that you are not violating and giving legal advice, but just giving explanation. Thank you.
Thank you, Ms. Armstrong. And Mr. Barr, same question.
Thank you. The way the question was posed, I assume we're speaking of the community of the 14A2 District Court, which I would consider to be the voters and the ones most affected and least understanding of the court, probably the most impacted area by not knowing. But I think the question is also broader, because there's the law enforcement community. There's also the legal community, notably those that do not regularly practice in the 14A or 14A2 District Court, that can learn great amounts on how to be more effective and how to be more efficient. The judge would have great influence over simple ways to get that information out, by way of giving information at the start of their docket, by way of giving certain instructions to their staff and the court clerks, of which of course cannot get legal advice, but can steer in a couple directions that I'll get to in a moment. There's also the court's website, which has a copious amount of helpful information for legal practitioners that could also be accessed by citizens themselves. So there is quite a bit that the judge can do to do that. There are community resources by way of legal services of Southeast South Central Michigan. The court can allow law students to practice and help pro per litigants. And an example of that is U of M Student Services Legal Clinics, as well as the DRC. And I would echo the previous comments about engagement in the community, and further believe that my 20 years of engagement in the 14A2 District Court community would make me the best candidate for that, because I have those ties and I can be the best to get that word out there, help pro per as well as the bar itself to be more efficient, be more effective, and serve justice to all people. Thank you.
Thank you, Mr. Barr. Thank you all the candidates for your responses to the questions. It's now time to have your closing statements, which will be 90 seconds. We will begin with Ms. Armstrong.
Hello again. My name is Fawn Armstrong, running for 14A2 District Court. As I've said earlier about my experience, I'm currently assigned to Circuit Court. I see a lot of cases with a lot of young people who are facing serious charges. And I just think that we could have intervened in their lives sooner. And I think you do that right at district court, because you can reach people and give individualized programming, really reaching the issue in the core of what brought them here. There's a lot of people that have their own histories, their own traumas, that really cause them to act in certain ways. And if we can help them, and I think that one of the biggest things to motivate someone to change is hope. If you believe in somebody, they might believe in themselves. And that's what I want to give as a 14A2 district court judge, is hope and believing in someone and trying to motivate them to want to change. I think that at district court, there's just so much more time that you can devote and really spend time listening to people and really being invested in their lives and what's happening with them. And that's what I plan to do as 14A2 district court judge. And I thank you for your time.
Thank you, Ms. Armstrong. Mr. Barr, closing statement.
Thank you. Most of what I learned, most of what I stand for, I learned in Boy Scouts. My core values, predominantly, you can trace that back to the Scout law. Scout is trustworthy, loyal, helpful, friendly, courteous, kind, obedient, cheerful, thrifty, brave, clean, and reverent. Those are the tenets that I would bring with me to the bench. I believe in the rule of law. Rule of law to me means that everyone is treated equally, no matter of their race, color, sexual orientation, whether they have money in their pocket or whether they don't, that they all get a fair shake. They will all be fairly heard, listened to in my courtroom. As I mentioned before, the primary thing I want to build is create more trust between the community and the court. And that somewhat expands, leans over to the criminal justice system with regards to the police, which obviously I would not have control of. But that trust, that understanding is the best thing, in my opinion, that we can do to not have an unarmed citizen killed by police. That is the most serious thing we do not want, and I would like to help prevent. Thank you.
Thank you, Mr. Barr. Mr. Collis, closing statement.
Thank you. I look at the district court, and I think it's important for people to understand what the district court covers. The district court covers civil cases under $25,000 in value, traffic, misdemeanors, landlord-tenant, and the beginning stages for all felonies. Of all the candidates here, I am the only one who handles on a daily basis every single type of cases that are heard in the district court. I have practiced in nearly every single district court in the state, if not everyone. I can't recall all the cases where I've had matters in the district court. I have experience and have handled mediations. I'm able to make sure that the court system works for everyone. And we need to have a court system in 14A where people are not afraid that lawyers or judges are going to bamboozle them. They don't understand how the system works, or they have a system where they have no fear of the actual system. We need to give them understanding. We need to give them knowledge, and we need to teach people what's fully expected of them. And everyone deserves fair, equitable, and compassionate treatment. My experience, not only in the district courts of this state, but in other states, give us the opportunity to give us the best possible judge. Thank you.
Thank you, Mr. Collis. Mr. Feaster, your closing statement.
Thank you, Ms. Doolin. Thank you to the League of Women Voters. Thank you to the Dispute Resolution Center. Thank you to the Washtenaw County Bar Association. I appreciate you all hosting this forum and giving us an opportunity to educate the public about who we are and what we stand for. As I said, my name is Torshel Feaster. I am an attorney. I am a father. I am a husband. I believe that I am a great candidate for this position because I have a vision for our future, a vision for Washtenaw County, a vision for where our court can go. I have the 15 years of experience. I have served in a quasi-judicial role for the past 4 years as judge of a Blight court. So I know how to deal with residents. I know how to give people opportunities. I know how to read when people are doing things that are manipulative. And I've been able to see that, and I've been able to work with people to get through those type of difficulties. I believe that I bring a unique perspective to this position. Should I be successful in receiving this role, I'd be the first person of color to sit as judge of the 14A2 District Court in Ypsilanti. I believe that could be huge for that community. I believe it could be huge for this court. I'm looking forward to the opportunity to get to meet everybody. I'd ask you to please check out my website at Feaster, F-O-R, feaster4judge.com. Feel free to reach out to me, call me with your questions, comments, and concerns. I'm looking forward to talking to you and telling you why I feel I'm the best candidate for this position. And please vote for me on August 2nd. Thank you.
Thank you all. We appreciate you being here tonight, and thank you for this valuable session. This will conclude the questions, and I'm going to turn it back over to Carolyn for her closing comments.
Okay, the League, the Dispute Resolution Center, and the Washtenaw County Bar Association thank all of the candidates for participating in tonight's forum, and also want to thank those who contributed questions. All our candidate forums will be available for streaming from our website, lwvwashtenaw.org. The forums can be viewed on Ann Arbor's cable television news and at the DRC Facebook page at Dispute Resolution Center A2. Please urge others to watch these forums, and please share the links with them. For additional nonpartisan information on candidates and ballot issues, go to vote411.org. The League's voter resource guide covering local, state, and federal candidates and current proposals that will appear on your ballot. As a reminder, all voters are now eligible to cast an absentee ballot, and Michigan law now provides for Election Day registration. Whether by absentee ballot or in person, please vote in the August 2nd primary election. Thank you and have a good evening.